So a person holding a medical marijuana card and also having a license to carry. Can you talk a little bit about if they can have both, how that, I know one of the things that we actually, because you're here and you're an expert on the subject matter and part of this is a question that, to be honest with you, we have avoided having in our lives because we know this is a very controversial question. So can you share with us kind of how that works and how, really everything around it, that would be great.
That is a very good question. That's actually one of the ones that I get a lot too. And even, a lot of times when I get that question, it's in the form of an application for a license to carry. And you have an interview with the person and they bring it up. So in Massachusetts, the first thing to remember is the medical marijuana law in Massachusetts requires that if the person qualifies as a patient, that there is no civil or criminal penalty and that they don't lose any right or privilege going forward for whatever that may be for those actions. So in Massachusetts, speaking specifically, the Executive Office of Public Safety and Security has addressed this with that we will continue to issue those license to carries. So in Massachusetts, there's 2 times when you can be denied. The first time is you can be disqualified because of a criminal history, right? Or mental history or that type of thing where it's documented. And it's a statutory disqualifier. And that statutory disqualifier is anytime there's a conviction of a crime that would have carried more than 2 years in the House of Correction or in prison. So that's the there's a disqualification for the statutorily. The other one is for if the licensing authority felt that it was a suitability issue for whatever reason. Then it has to be articulated and it can't be arbitrary or capricious or anything like that. Where a medical marijuana card, when we do the background check, we do a board of probation check, we do a III, which is across the country type of check. They don't check the person's status as a medical marijuana patient. It's not part of the background check. And when I actually put down when you apply for your license to carry, one of the questions is, have you ever been convicted of the unlawful use, possession, or sale of controlled substances as defined under 94C, Section 1? And so that other issue, that 2 years I was talking about, possession of marijuana in the past was a misdemeanor. It was up to 2 years in prison, and then the second offense was over 2.5 years. So even though that occurred as it could be a statutory disqualifier, we don't apply that anymore. So if you have a possession conviction in Massachusetts, that license will still be issued. All right, and same holds true for if the person has an active medical marijuana card. Now, that doesn't mean that you can carry while under the influence, right? So in Massachusetts, if you were given a license to carry, you also, again, just like driving, you have to be careful that you're not possessing a firearm while you're under the influence. And again, that same standard as like an OUI might have to be met. So, and that again, that includes alcohol, that includes any other type of drug. And so that could be a reason to disqualify somebody or suspend their license. And that kind of thing. So the short answer is yes. If you do have a medical marijuana card, you can still get a license to carry. And if you do have a possession conviction in the past, you can still get a license to carry. There could be issues with distribution of Class C, THC. So if there's a distribution issue, that could still be a statutory disqualifier.